In Premchand versus State of Maharashtra, the case deals with the conversion of a conviction under Section 302 IPC, that is murder, imposed by the trial court and affirmed by the Bombay High Court to conviction under Section 304 IPC, which is culpable homicide not amounting to murder. The case focuses mainly on the provision of Section 313 of CRPC, which is the power to examine the accused. The court referred to a chain of judgments to point out the relevance of Section 313. The first one is State of UP versus Lakshmi, which gives the value of a statement under this section. Object of Section 313 was pointed out in Sanatan Naskar versus State of West Bengal. In Reena Hazarika versus State of Assam, rationally behind a requirement to comply with Section 313 CRPC is given. And Parminder Kaur versus State of Punjab and M. Abbas versus State of Kerala points out the importance of Section 330. Summarizing all these cases together, the Supreme Court came up with 10 well-settled principles, which is clearly explained in the judgment in paragraph 50. In the light of the well-settled principles, every criminal court proceeding under Clause B of Section 1 of Subsection 1 of Section 313 has to shoulder the onerous responsibility of scanning the evidence after the prosecution closes its case, to trace the incriminating circumstances in the evidence against the accused and to prepare relevant questions, and to extend opportunity to the accused to explain any such circumstances in the evidence that could be used against him. And as per Section 13, Clause 4, the answers given by the accused may be taken into consideration in the trial and put in the evidence for or against them in any other trial for any other offences, which the answer would suggest they have committed. And in 2009, by the way of an amendment, Section 313, Clause 5 was inserted, where the court takes help of the prosecutor and the defense counsel in preparing the relevant questions that are to be asked to the accused, and may also permit filing of written statement by the accused, denoting sufficient compliance with the provision. The intention behind the amendment was to ensure fair but speedy trials. The Supreme Court observed that once a written statement is filed by the accused under Section 313, Clause 5 of the CRPC, and the trial court marks it as exhibit, such statement must be treated as a part of the statement of the accused under Section 313, Clause 1, read with Section 313, Clause 4 of CRPC. The exercise under Section 313 should be realistic and act as a means in securing the ends of justice. In the present case, neither the trial court nor the High Court looked at the written statement of the accused. Therefore, in this case, the court noted that the police failed to investigate the injuries suffered by the accused. And it has been almost a decade since the incident took place, and directions to investigate the case is not found to be fruitful. And hence, the Apex Court thought it fit to release him from custody. Thank you, sir.
This case reminds me of the case that we discussed yesterday, which is BLS Infrastructure Limited versus Rajwat Singh and others, in which I invited an attention towards a law commission report wherein it was recommended that the parliament must intervene and the relevant amendment must be brought in within 256 of the CRPC, so that the intervention of the appeal courts is not required and subordinate courts are given with inherent power so as to further reopen a closed complaint if there is certain judicially satisfactory reasons are appended by the complainant. Similarly, in the present case, even though a parliamentary amendment was brought about and a section was added, that is 313 clause 5 was added, the same is not being utilized. As mentioned by the present, that is Nivea, uh, it is said that it was amended in 2009 by considering the instances of interference with conviction by court of appeal on the ground of failure of trial court to frame relevant questions and to put the same to the accused were not rare. Court noted that if facts within the special knowledge of accused are not satisfactorily explained, that could be a factor against accused. So that is the view taken by Supreme Court in this case, which shows that even though the legislature has incorporated means so as to reduce the unnecessary cost and to secure the ends of justice, the same is not being fruitfully followed by the trial court, and causing unnecessary delays, of which this is a special and a clear case wherein he was imprisoned for more than 9 years in prison. Sorry, 6 years in prison, I believe, uh, for an offense wherein he should have been convicted under Section 304, but he is convicted under Section 302. And surprisingly, High Court also did not intervene in this matter. So, Section 313 CRPC envisages that a statement has to be given by the accused as a part of audi altem partem, which finds its root to principle of natural justice, which has been mentioned in a judgment of uh, Rajkumar Singh at Raju versus State of Rajasthan, which is AIR 2013 SC3150, wherein the purpose of examining the accused under Section 313 was given by Supreme Court, which is mentioned that the purpose of empowering the court to examine the accused under Section 313 CRPC is to meet the requirement of the principle of natural justice, which is audi altem partem, that no one should be condemned unheard. This means that the accused may be asked to furnish some explanations as regards the incriminating circumstances associated against him, and the court must take note of such explanations. In a case of circumstantial evidence, the same is necessary to decide whether or not the chain of circumstances is complete. So, the purpose of examining the accused was well explained in Rajkumar Singh's case. Similarly, the scope and object of Section 313 CRPC was given in Sanatan Nashkar and another versus State of West Bengal, which is already explained by almost all the respected members. My scope with regard to this case is squarely concentrated upon only a small aspect, which is the important cautions while making or using the application of statement under Section 313 CRPC. So again, I'm quoting the same judgment, which is Sanatan Nashkar and others versus State of West Bengal, wherein it is said that the court must rely on a portion of the statement of the accused and find him guilty in consideration of other evidences against him, led by the prosecution. But such statement of under Section 313 CRPC should not be considered in isolation, but in conjunction with the prosecution evidences. Secondly, conviction cannot be based merely on the statement of accused under Section 313 CRPC. Basically, in this judgment also it is mentioned that there is two parts for a statement, which is exculpatory statement and inculpatory part. Exculpatory part means it is something which finds more closeness to the, the statement of the accused so as to free him. And inculpatory part means which finds more affinity towards convicting him. Here, the Supreme Court noted that High Court gave more attention, and as well as trial court gave more attention to inculpatory parts and gave no attention towards exculpatory parts, which led to the conviction of the accused. So that should not be done. That is what it entails. Similarly, in Rafiq Ahmed at Rafiq versus State of UP, which is AIR 2011 SC 3114, the court observed that it is true that the statement under Section 313 CRPC cannot be the sole basis for conviction of the accused, but certainly it can be a relevant consideration for the court to examine, particularly when the prosecution has otherwise been able to establish the chain of events. Thirdly, adverse interference against the accused. In the case of Phula Singh versus State of Himachal Pradesh, which is also a Supreme Court decision, wherein the court held that accused has the right to maintain silence during examination or even remain in complete denial when his statement under Section 313 CRPC is being recorded. But in such an event, adverse interference could be drawn against him. That was mentioned in that case. False denial made by the accused of established facts can be used as incriminating evidence against him, which is mentioned in Supreme Court judgment, which is Munna Kumar Upadhyay versus State of Andhra Pradesh, which is AIR 2012 SSC 2470. Similarly, an adverse interference can be taken against the accused only and only if the incriminating material stood fully established and the accused is not able to furnish any explanation for the same. which is, as already mentioned, case which is Rajkumar Singh case, which is Rajkumar versus State of Rajasthan. Then, lastly, which I would like to mention is regarding the last portion, which is of this judgment, wherein which is some latest judgments of certain individual high courts, wherein recently Calcutta High Court in Nanda Samanta versus State of West Bengal had set aside an impugned judgment of conviction because of the reason of non-recording of statement under Section 313 CRPC. Supreme Court in Jai Prakash Tiwari versus State of Madhya Pradesh held that it is the duty of the court to consider the defense presented by an accused and give reasons in writing while adjudicating the same. And lastly, uh, in Kali Charan versus State of UP, it was held that if the accused is not explained the important circumstances appearing against him in the evidence on which his conviction is sought to be based, the accused will not be in a position to explain the said circumstances brought on record against him. He will not be able to properly defend him. The bench of Justice Sanjay Krishan Kaul and Abhay S. Oka has said in this present case. So yes, that is what I understand with regard to the relevancy, and almost all the points has been mentioned by the respected members, and Alexi Joy has also mentioned all the points with regard to the Section 313 CRPC, which has been encapsulated in this judgment. Yes, thank you.